to you. To my right, Judge Tim Easter from Williamson County.
That's correct.
To my left, Judge Jill Ayers from Montgomery/Davidson County. And I'm Robert Holloway from the mule capital of the world, Columbia and Murray County. And we have 4 cases this afternoon. Any preliminary announcements?
No, Your Honor.
All right, as the attorneys know, the appellant needs to request rebuttal time if they would like that. With that, would you call the first case, please?
State of Tennessee versus Richard Lawrence, Canada.
Good morning, Your Honors. Pat McNally of the Nashville Bar, and I'm here on behalf of the appellant, Richard Kennedy. I would like to reserve, 3 minutes for my rebuttal. And if it may please the court, this case presents fundamental questions. The first is about the sufficiency of the evidence as to whether there was sufficient evidence presented by the state for both theories of rape by fraud and rape by non-consent. The second part deals with the question of whether the sentence was excessive, of 11-year sentence for a 70-year-old man with no prior convictions at all. The range of that sentencing was 8 to 12, so he's 1 year shy of the maximum. The unique aspects about this particular case is that you have a video of the encounter, of the alleged rape. And I emphasize to the court that this is very important to review because you actually can see what is occurring between the young lady and Mr. Kennedy through the 16 minutes of the video. In fact, it's kind of uncommon for a rapist to supposedly videotape their criminal act, preserve it, tell the person that they're videotaping it, and then actually cooperate with the police when they come in, when they do a search warrant of his home to try to find evidence. And that tape is what's so essential to show there is insufficient evidence for a conviction of rape by fraud or rape by non-consent in this case. Because in that videotape, you will see that the young lady, well, first of all, that they discuss about the nature of the massage or sexual massage that's going to occur. They talk about whether she's ever had an orgasm before. Mr. Kennedy checks in with her during the course of the massage, not once but twice, ask her, is this okay? Are you okay? And
So you're saying on the front end, he tells her what he's going to do?
Yes, at the beginning of the tape, he begins he starts with introducing her to the massage room, to ask her to sit down on the pallet, pull the blanket over her, and then he begins the massage with oils and starts to massage her in her private area. And during the course of that, at that point, he starts saying, have you ever had an orgasm before? He actually, at one point, while he's penetrating her, says, I'm trying to get you to release, and she giggles and says, I probably won't because I'm menstruating right now. So they're having an open discussion during the course of this 16 minutes. I hope that answered that.
Yeah, well,
I will say that at the very beginning, he sits down and says, have you ever had...
Well, that's kind of what you made it sound like, and obviously we haven't seen the video, but we will watch it. So I just was curious as to how you were characterizing how he described it on the front end.
Certainly, at the time when he's penetrating her or getting into more where her bathing suit pants are off, he begins to talk to her about that and says, I want to help you release. I want you, and she's chuckles. She's involved in a conversation with him.
And is the whole encounter on the video?
No, the latter part of it's not, but the beginning of it is. But the 16 minutes that you get is really the significant parts of this that were part of the state's election for the offenses involved in this particular case. There's 8 different counts, 4 rape by fraud and 4 rape by non-consent. They were consolidated at sentencing hearing, and the video of the 16, they go through the election of the offense about she's on her back at the time this is occurring, she's on her stomach at the time this is occurring. She is on her back when he is performing cunnilingus on her and things of that nature.
Mr. McNally.
Yes, sir.
It seems like you've had more than your fair share of these kind of cases, and I don't mean that in any degrading way at all. It's just that, is there anything here that you're telling us that the jury did not hear? Because when the way I see this case, it's like others that you've argued here before. She said this, he said that. Jury believed her, and therefore convicted him, and so that's sufficient under our law.
However, and there's,
Tell me.
There's two parts there I'd like to address.
Please.
You have a section where I wanted to distinguish. You're right. I've had it seems like a rash of these cases have been coming up. Not only myself, but Ben Rabin had one of them up here at D. DeMonico. Your Honors sat on two of my cases, and Your Honor wrote maybe both opinion. I know the Funkham opinion. And I want to distinguish those. If I may start with that, then I want to talk about how important it is for this court to still be a reviewing court.
Okay.
And not to shuck, I don't mean that word necessarily, but not to let the jury decision necessarily, what's the word I'm looking for? Not to necessarily cause this court to default or not review questions of insufficiency of the evidence.
Sure.
In the three cases that I'm familiar with, Durden and Funkham, those two I was up here in front of. In both of those, they're non-consent cases. But in Durden, the young lady, when he asked, if you remember, in Durden, he asked his wife, "Can we have sex, or do you want to have sex?" And she said no. She then takes a Benadryl and some alcohol and goes to sleep. Now they're sleeping in different bedrooms. They're estranged, they haven't gotten the divorce yet, but they're headed that way. And there's very clear from the evidence that she was not consenting to having sex with him that night. And though she didn't remember it, the next day he denied it, and then eventually it came out that he did have sex with her. In Funkham, two people are out. They've been drinking. They've been carousing. She goes to bed on her own, and she does not give any indication that she wants to have sex with him. He thinks she does, and he goes into bed with her, and she says stop, and he stops. Again, there was evidence there to show that a reasonable, that's the standard, a reasonable person would have known that she was not interested in having sex or was saying no, not consenting. The third one, D. DeMonico, in that one, she actually says, no, I don't want to have sex. They were sleeping in separate bedrooms. He goes in after she takes an Ambien and takes advantage of her. There was clear, again, the evidence there was very clear. Here, in this case, the evidence is not there. The evidence here, no, there's never any words of saying no. There's never any prior times where there's any kind of contact where she says, I don't want to have sex with you, you 70-year-old man, I don't want to have sex. She never says anything like that. There's no alcohol involved. In fact, every single part of her behavior manifests verbally, physically, and emotionally that she is consenting to this. That's the big difference between those three other cases and this one here.
But I'm sure at trial, the prosecution asked her, did you consent to this, and how did she respond?
And she said no. Now, here's the important thing. She says no, but every part of her physical, verbal, in fact, emotional, by giggling. Now, the state says it was nervous laughter. I said it was giggling. Either way, it's evidence of levity. All those indicate that she is not non-consenting. That's a double negative there, but she's consenting. And it's not what she says necessarily. It's the standard is, did he know or should he have known from a reasonable man's perspective that she was not consenting? And that's the difference in this case. There is nothing here that would suggest that Mr. Kennedy should have known that she was not consenting. Everything indicated she was. Their conversations, her actions, her cooperation of sorry to get so blunt, but her cooperation of spreading her legs when he's beginning to penetrate her, everything indicated that she was consenting from a reasonable, objective, reasonable man's perspective. I think that's the standard that D. DeMonico talks about, the objective standard. Now, here's, if I may go, I was actually going to do this for my rebuttal, but I'm going to go right into it. This court still has an obligation to review convictions, to make sure that a person is not wrongfully convicted. Everybody always relies on Jackson versus Virginia for this high, very deferential standard to the state. And I understand it. It is, and it should be. It should be, because there's been a trial, there's been a conviction, and the jury has come back with the conviction against the defendant. So rarely should this court be setting aside those convictions. But it still has that obligation to do it. And everybody forgets about the other part in Jackson that no one should be convicted without proof beyond a reasonable doubt. That's on page 316 of Jackson. The quote is actually, a key aspect of due process under the 14th Amendment is that no one should face a criminal conviction without sufficient evidence. And that, Your Honors, is what I want to emphasize here. While appellate review generally respects the jury decisions, the court must intervene when a conviction is based upon insufficient evidence or wrong evidence. And while I understand what you're saying, in fact, the state argues, well, if she says it's not consent, that's enough. No, it's not. You have to look at the whole case. And if the jury made a mistake, the jury made a mistake, and this court is obliged to correct that. This goes a little bit into post-conviction, which I'm not raising here by any means, but I can see how the jury made a mistake here. Your Honors have all sat on trials. Rarely, if ever, does the defense counsel waive and never give an opening statement. Here the state gave a very powerful opening statement and defense counsel gave nothing. Cross-examination of the young lady. Nothing was done about, did you giggle? Did you say, yes, I'm okay? Did you affirmatively tell him? The cross-examination, it's about her relationship with him, not about the things in the video. I don't even know if trial lawyer looked at the video. Getting off record here, but to me, it appears trial counsel didn't even look at the video because I got a page and a half right here of the things from that video that I put down in the brief that talks about things that suggest that she's giving to a reasonable person every indication of consent. And so,
Do you agree that, like, the initial purpose, again, I've just read the briefs and haven't gone deep into the record, but it seems like from the facts of the case that the initial setup was certainly fraudulent to some extent. The way by which the defendant got her to come over and told what he was going to do to her and to her mother. So do you agree that that part was deceptive?
yes, I'll concede that the suggestions that you're coming over for massage and perhaps even that I've got a class I'm attending, though I will say Detective Horst admitted that even though she couldn't confirm that there was a class that he was attending for this massage, learning massage, that she couldn't rule out that there weren't some other places. But you know, what you had was, the state argues that he has set this up to look like a massage with candles and a quiet. It's a massage that goes into sexual acts. I don't know that there's deception that he's only going to do a particular type of massage. And I'm not trying to evade your question, but yes, he invited her over for a massage. She came over, and he had a room set up, and then he proceeded with the massage. What's interesting about whether it's rape by fraud is that when you look at the statutory elements is that the penetration has to be at the time or the fraud has to be at the time of the penetration, but it has to be fraudulent inducement to the penetration. And you look at the cases like, Tizard, where the doctor fraudulently tells a kid, I need to rub your penis in order to give you medical treatment for steroids. You look at the situation of Marcos Enrique, where the defendant was telling the victim that he had magical powers, and if she had sex with him, he could heal her family. Or Madison, where the victim was threatened with a false prosecution. Here, there is no inducement for the penetration by fraud here. His acts, his discussions with her and his acts are very clear, very upfront. There was no fraud that induced the penetration. But here's the other thing that I found was really particularly interesting in these two theories here. The young lady testified that when I first walked in the room, I was a little bit surprised. I was trying to get the exact word. I was uncomfortable. And then she says that I was in shock. I didn't resist. I didn't say no because I was in shock. I was frozen with fear. That's her testimony. Now, is it that she's not consenting because she's frozen in fear and thus no fraud's being induced for the penetration? Or is it that you can't have both of them? In other words, what I'm saying is the state can't get both bites of the apple in this particular case because either she's frozen in fear and not consenting, or she's consenting by some sort of fraudulent behavior, and that's not the case here. She knows what's happening. She knows what's going on. And if you accept her story as to why she didn't resist, which, by the way, is not a defense alone, or is not sufficient to convict alone in this case, but if you accept her testimony that I was in shock, I was frozen with fear, I didn't consent, or that's why I didn't resist to show my non-consent, that's a non-consent, not fraud. Now, the state does argue that that non-resistance does not equate to consent. And that's a good point, except it's not alcohol in this case. This is not a case, the state is conflating non-resistance with affirmative actions by her. This is not a case of non-resistance. She's affirmatively, both physically, verbally, and emotionally, responding and communicating with Mr. Kennedy. This is not where she's laying quietly, silently, like some of these other cases that we've seen. She's actually verbally engaging with him and giggling with him. And that's why I'm saying that the state relies on the case, actually came out of Your Honor's court, Donoff, and I read Donoff carefully. And
It's my very first jury trial.
Was it really?
It was.
Oh, what a tough one to get. Yeah. But in Donoff, what actually happened was there was actual force or coercion on the victim in that case. It was not a case of where the child lay there, silently and didn't resist. She said no, and there was coercion in that case and everything. But they give some of that language of going back to previous cases about the non-resistance. But that's where someone doesn't do anything. Here, this person was physically, verbally, and emotionally exhibiting to a reasonable person, again, that she was consenting to it. I'll move on to the sentencing, which won't take long, but I've got 1 minute. I know that the standard for review of sentencings in Tennessee is that this court reviews them de novo with a presumption of correctness, and it gives the opportunity for the court to review it for an abuse of discretion. An abuse of discretion occurs when an improper legal principle is applied or there's been an unreasonable finding of facts by the court. In this case here, the unreasonable finding in particular, was number 14, the private trust. If the court here were to affirm the finding of number 14 enhancement factor of private trust, that would be contrary to three cases in particular. That would be contrary to the Frost case, which says that that's not sufficient for a private trust. It would be contrary to Gutierrez, which says that there has to be some special relationship of vulnerability, and to Brown, which clarifies that relationship must cause the adult victim in the particular case to be vulnerable. And vulnerability is built upon reliance, confidence, or faith. In this case here, it's clear the testimony is that they were merely neighbors, that any relationship between the young lady was with Mrs. Kennedy, and it was very tangential, very marginal. She watered her plants a couple of times. She'd been, and the young lady admits that she'd only been to the house once or twice before. She's never been alone with Mr. Kennedy until this particular occasion. And I understand that under the Supreme Court and this court's decisions, that if the court can enhance a sentence if they apply one enhancement properly, even if there's some other enhancements that are not applied properly. What I'm asking is for this court to look at the overall sentencing and bring this down from 11 to 9 or 10, an enhancement, but also to correct that this private trust should not occur in this case. Otherwise, it will set a dangerous precedent, contrary to Tennessee Supreme Court and this court's law. Thank you.
General?
Good afternoon, and may it please the court. Caroline Weldon on behalf of the state. This court should affirm the judgments of the trial court because the evidence was sufficient to sustain his convictions, and the trial court properly imposed his sentence. The defendant denies that the evidence is sufficient to support his convictions, but the arguments that he raises are about the weight of that evidence and not its sufficiency. The state's evidence at trial was overwhelming. The victim testified about what happened at the defendant's house, and the jury watched a recording of what the defendant did. And this court should affirm his convictions from that evidence.
Other than her testimony at trial that she didn't consent, What was it in the video that demonstrated that she did not consent?
Well, first, I'd like to clarify that the discussion that they had before the massage began is not captured in that recording. So that conversation, she testifies about what that entailed at trial, but that's not a part of the recording. The recording is limited to when her body is already on top of this sort of makeshift pallet in the defendant's living room. And you can tell her body is tense on the table. She's doing what the defendant asked her to do, and what her mother had asked her to do, which was to go over to his house, wear clothing that he could touch her elbows and her knees. But then once she got there, he asked her to take that clothing off. She's in a sports bra and bikini bottoms, and she's laying there, and you can see her body kind of tense as he begins to slather her with oil. And she's not engaging in conversation with him. They're not really speaking. He's saying some things, and it's a little hard to tell with the spa music that's playing in the background, but there's no back and forth conversation. He's making comments to her. He's kind of walking her through what he's about to do. And again, that's to further the ruse that this is a legitimate massage. Because part of what the defendant did when the victim arrived to his house was to gauge how familiar she was with a massage. So he asked her whether she'd ever had one before. And when she told him no, that she hadn't, he had her remove her clothing and lay down and begin the massage. And that's how he was able to assess how far he would be able to take that massage once she was laying down.
At some point, I mean, the sexual act seems to become obvious. We haven't seen the video, but based on what we're hearing, I mean, is that not correct? And once it becomes obvious, it seems like she makes no response, that she does not consent to that.
She doesn't have the opportunity to give a response because almost as soon as she's laying down on the pallet, he begins to focus all of his attention onto her buttocks and is adjusting her bathing suit bottom to expose more and more of that area. And then he begins to insert his fingers into her vagina. And she is still under the impression that this is what a massage should be and that this is part of a massage.
Is that what she testified to?
Yes.
And
Yes, Your Honor.
This victim is 20 years old. Is that right?
Yes, Your Honor, that's correct.
This is not a minor we're talking about. We're talking about an adult woman who thought this was part of the massage.
Yes, Your Honor.
Was there anything in the evidence that prevented her from getting up and leaving? I mean, was he forcibly holding her down?
No, Your Honor, he was not forcibly holding her down. She testified that she did have her cell phone, that she could have left. He did not try to convince her not to leave. But I think that it's important for this court to understand the context in which the victim arrived at the defendant's house that evening. She's 20 years old. It's, I believe, summer of 2021. He calls her mother, not her, calls her mother, who's a good friend of the family, repeatedly in search of her, in desperate need of the victim to come and assist him with a massage project, which she believed to be legitimate because she knew that he worked at a gym and thought perhaps he does take a massage class because of the nature of his work. So during that phone call, he explains that he'll need to touch her elbows and her knees and that she should wear clothing that allows for him to touch her. So by calling her and by bringing her mother into this ruse, he's establishing that she's going to come to his house for this apparently legitimate reason, that he's going to touch her when she arrives at his house, and that he will perform some sort of massage.
How under all these circumstances could the defendant know or have reason to know that she did not consent?
Well, I think it's established by the way that he was able to bring her to his house. He's creating two layers of a ruse, first by getting her to his house, and then once the massage begins, he's trying to show that this is what a legitimate massage should be, and she simply did not know that that was not what was part of a massage.
And she also knew that by taking off the clothes that she took off, she was taking off much more than was needed to have her knees and elbows massaged, correct?
That's true, but as the victim testified to at trial, she trusted him. She'd known this man since she was a young child. She had lived across the street from him for years. Her mother had said, okay, you can go to his house to help him with this project. And she believed him. She believed that she was there to assist him, and she testified that he was an older person, an authority figure, who she had known since she was a very young child, and so she did what he asked her to do. And
Well, that's a very different portrayal of that relationship than we heard from the defendant. I mean, that's not shocking, but what was the actual, I mean, is there proof in the record that she literally had only been to the house one time? How well did she know this person? I mean, because you're making it sound like, you know, they were very close and had this strong relationship. The appellant's certainly saying that it was not like that, and she'd only been over there once and really never dealt with the defendant, only with his wife. So, what's the real evidence going to show us?
sure, the evidence at trial shows that the families were close, though it was primarily the women. It was the defendant's wife and the victim's mother who had a strong neighborly relationship, in that they would look after each other's houses when they went on vacation, cared after each other's pets, watered each other's flowers. And although it was the defendant's wife who helped make those arrangements and schedule the flower watering with the victim, that's how she knew the defendant, was because of her mother's relationship and her relationship with his wife. And so she did go to his house, but it wasn't at his invitation. It would have been because his wife had invited her over to do homework on occasion. At one point, the family went over to see a bathroom that they had renovated at their house. So it's true that the victim and the defendant did not have their own relationship, and I think that's evidenced by the fact that he didn't have her cell phone number. He had her mother's, and that's how he was able to reach her. But the families had a long-standing 20-year relationship, and she knew him as her neighbor across the street for practically her entire life. And that's precisely why he picked the victim in that late hour to come over to his house and to assist him if there were some consensual or other sort of relationship that they had between them. Otherwise, he could have just reached out to her and asked her to come over, or seen her outside and invited her in, but he needed all of these different layers of the ruse to make it work, to make it be believed by the victim, her mother, and then his wife, should the women speak upon her return from caring for her grandchildren. So again, I think the context is especially important to understand how the defendant was able to get the victim into his house that night, and then how he was able to continue performing this massage for the amount of time that he did. And Mr. McNally is correct in that the video shows in very, very clear imagery all that the defendant does to the victim and her lack of engagement with him throughout the entire massage. She's laying there. You can see her kind of bracing on the table. She tries to adjust her clothing so that it's not so revealing, and he continues to push it and pull at it. At one point, he reaches for a vibrator sex toy and refers to it as a massage stick. And again, she's face down on the table, so she doesn't know what exactly he's doing, and she again believes him because it's her neighbor who she's known her entire life. And the defendant's employer from the gym testified at trial that no part of his job responsibilities involved massage, and that facility had not paid for him to be a part of any massage class. So again, this was simply a ruse to bring the victim over to his house, and he took elaborate and great steps to create a spa ambiance in his living room, setting up a palette, having dark lighting, candles, an anatomy book out, and then conducting this interview before the massage began to kind of gauge how far he'd be able to take the massage. And again, all of the massage is captured on on film. And
Is it like all the way through when it's over and she gets dressed and leaves?
it stops before she exits the table, but it's probably about 16 minutes of the camera positioned right across from her body, and you can see every detail of their encounter. And the defendant's face is plainly visible. He's clothed, she's mostly not. He's panting, and
So how does it end? I mean, what does she say happened when it's all over?
the recording just clicks off and fades to
Right, but
black.
I mean, after the video, what does she say?
Oh, excuse me. After the video, this isn't captured on video, but she testifies that it ends. He stops massaging her, and then she gets up and she finds his business card on top of her clothing, and she redresses, and he tells her that she should drink some water in case she's sore. And she feels uncomfortable, but she's still not sure if what he actually did was criminal. And so she calls her best friend and asks her friend, who she knows has had a massage before, and asks that friend if massage involves touching of intimate areas. And her friend says, no, it doesn't. And so at that point is when she realizes that what just happened was rape, and she reports it within hours. And that friend testified at trial and gave that account as well. If there are no other questions about the sufficiency of the evidence, I'd like to turn to sentencing. The defendant takes issue with his 11-year sentence, but the trial court complied with its duty to consider the purposes and principles of sentencing, the evidence, and the relevant statutory factors, and those decisions are supported by the record. It's undisputed that the defendant is a Range 1 offender, and he was sentenced for Class B felonies, and received a total effective sentence of 11 years confinement. And in reaching that length of sentence, the trial court applied enhancement factors 1, 7, and 14, and the defendant takes no issue with the application of enhancement factor 7. So even if for some reason this court finds that the trial court erred in its application of those other two factors, his sentence should be upheld for that factor alone. Although these were the defendant's first convictions, his criminal behavior is extensive, and that extensiveness is reflected on his electronic devices. Detective Smith testified at the sentencing hearing that there was child pornography on his laptop and his cell phone. Specifically, Detective Smith testified that at least one of the images of child pornography depicted a prepubescent female that was undressed from the waist down, being sexually abused by an adult male. And from that testimony, the trial court found, by a preponderance of evidence, that the defendant had possessed child pornography. And although the trial court also heard Detective Smith testify that the defendant had other, perhaps inappropriate images of children on his electronic devices, it made no findings that those images constituted child pornography, and those were not part of its analysis for applying enhancement factor 1.
How about the position of private trust? Did you find any Tennessee cases where being a neighbor to someone is a position of private trust, even a close neighbor?
I cannot, Your Honor. And I would agree that it would be problematic to say just any old neighbor would warrant the application of this factor. But this was not a mere neighbor to this family and to this victim for the reasons that I discussed with respect to their relationship. They were families that knew each other for 20 years, that assisted each other as friends. The victim worked for that family by watering flowers when they went on vacation. And so I won't belabor the points that I already made earlier in my argument, but this was not simply someone who lived on their street who she'd never seen before. Because if that were true, she would never have gone to his house. The only reason the defendant picked this victim is because he knew that because of this relationship with her mother, that she would go to his house dressed in the way that he had described, and that she would allow him to touch her in that way.
Did the mother testify?
Yes, Your Honor, she did. And she also explained the nature of their relationship and is able to provide more of an adult sort of chronology of when the family moved on to that street, how she became friends with the defendant's wife, and provides more of that context that the victim as a child wouldn't have been aware of. But the victim testified that she had known this family as neighbors on her street for practically her entire life, had been to their house on previous occasions, watered their flowers, and again, that's why he picked her.
Mr. McNally said that the fraud has to be at the time of penetration. Do you agree or disagree with that?
I would say that the fraud was occurring when he penetrated her. I think the fraud had layers to it. I think the fraud began when he made the call to the victim's mother to create this ruse of this massage class and this class project where another college student had failed to show up, and that's why he needed the victim. And then I think once she arrived, the fraud continued when he began this massage and led her to think that this is what a massage was, when in reality it was far from it. And this panel will see that when they watch the video. And if there are no other questions, I'd ask this court to affirm.
All right, thank you.
Thank you.
General Will. Mr. McNally?
I think it's obvious the state is conceding that the fraud has to occur at the time of the penetration by their comments just now, and that's what the statute says as well. But if I may go directly to a question about what was testified regarding the relationship. Because the problem here is the state keeps saying the families. They're trying to put this family on top to try to make a relationship out of a connection between the two women and not between Mr. Kennedy and the young lady. What was actually testified, volume 5, page 17, Mrs. Lumpkin says, "We were just neighbors. She knew Mr. Kennedy, but did not consider him a friend." Volume 5, page 17 again. Volume 5, page 16. "They occasionally helped each other with plants or pets." They, not necessarily the young lady who's the victim in this case. The young lady who testified, the victim, I'll just call her that here, the alleged victim, but she testified that she went to the Kennedy house, now, Your Honor, once or twice, is what her, and I've got it in quotes right here. That's volume 5, pages 35 and 38. "Never visited without Mrs. Kennedy present before this incident." Volume 5, page 37. And this is all in the brief as well. And then Mrs. Kennedy hired the young lady for yard work on occasion, and that's on volume 5, pages 16, 18, 35. Most of the dealings were between the two adult women, Mrs. Lumpkin and Mrs. Kennedy. The state is trying to bootstrap the mother's neighborliness into a trust relationship between Mr. Kennedy and the young lady. She was 20 years old. Under Brown and under Gutierrez, that is not a private trust. It's not the families that matters, it's the relationship of a vulnerability between Mr. Kennedy and the young lady. Now, I also want to
The
point out,
trial court used at least one other enhancing factor.
yes, and I have to concede, the court can enhance the sentence, but the trial court also rejected a mitigating factor by reaching outside the record, and that's part of why I think it ought to be down to 9 or 10 years. And while that may not sound like a lot to us sitting comfortably in this room and everything, or standing, to Mr. Kennedy sitting at Northwest Correctional Facility, reducing his sentence by a year or two is significant to him. I heard the word ruse. Oh, one other thing I wanted to mention. This is not just acts of massage by penetration with his fingers or with a vibrator. Mr. Kennedy is seen on that video committing cunnilingus, doing cunnilingus. Surely at some point a 20-year-old knows this is not a massage. And that's, part of the whole thing when you step back on this case, you kind of wonder, a 70-year-old and a 20-year-old and this is going on, why is that happening? On the other hand, you think a 20-year-old who this is going on with doesn't realize when this gentleman's committing cunnilingus that this is not a massage? I mean, they sort of balance each other out there. But I want to use this real quickly in my last 12 seconds. Ruse. I heard that several times here from the state. And it is not, it's either non-consent or it's fraud. It can't be both because, and I wanted to go over this She said, "I was uncomfortable when I walked in the room. I was frozen in fear and could not communicate my non-consent. She was not operating under the belief that sexual touching was a legitimate massage. She was frozen in fear, according to her own testimony. This is fatal to their fraud theory, because the young lady cannot have been induced by fraud to consent. That's what fraudulent rape is. It's being induced to the penetration by consent. That's why it's critical, Judge Holloway, that it is at the time of the penetration. Tizard, Enriquez, and the third case that I mentioned earlier all go right to that fact. It's using fraud to induce the penetration. It cannot be, it's either non-consent or it's fraud, and you can't have it both ways. The state cannot sit here and tell you that she didn't consent, but she also was induced by fraud. Mr. Kennedy, it cannot be, it's a reasonable objective perspective, and we cannot impose on Mr. Kennedy to somehow be a mind reader and know that someone's internal feelings are inconsistent with their behavior that they're exhibiting to the person. Thank you.
Thank you, Mr. McNally. Well, good briefs, good arguments. We'll take it under advisement and get it out as soon as we can. Call the next case, please.
Carrington Owens versus State of Tennessee.